If YouTube labeled certain videos as the product of what it labels as responsible news providers, that would be Google's own content, right?
Yes. Yes. And yes. Can I say one thing? Just because I forgot to mention thumbnails. Sorry. Thumbnails aren't mentioned in the complaint, so I was literally trying to figure out what he was talking about when I was up there, because it's just not something in the complaint. But that is a screenshot of the information being provided by another. It's the embedded third-party speech. Okay, sorry. Keep
All
going.
right. So but then if I do a search for today's news in YouTube, in fact, I did that yesterday, and all the top hits were very well-known news sources. Those are not recommendations. That's not YouTube speech. The fact that YouTube put those at the top, so those are the ones I'm most likely to look at. That's not YouTube speech.
Right, but I mean, all search engines work the same way. If you type in whatever you type in, there is a algorithm that's deciding what content to display. It has to be displayed somehow. And what I think is going on YouTube, or it's certainly going on Google search, is they're looking at, well, what did other users look? How popular was it? That kind of thing. You know, is that news source, from Russia? Probably not going to get on the top list. So yeah, they're having to make choices because there could be over 1 billion hits from yours. And there are a billion hours of videos watched each day on YouTube, and 500 hours uploaded every minute. So it's a lot of content on YouTube. So some of it's based on channels and some of it's based on searches, but they have to organize it somehow. But that is what's going on, I think, on your top searches, and most search engines too, and you can look at the Microsoft brief. They're basing it on what time spent on those news sites, how many users are looking at them, how relevant it is. If you're typing in the Turkey earthquake, they might be elevating some stuff that's featuring that because it's seems more relevant. If there's a recent election, they might feature that. So all these kinds of decisions are being made by websites every day.
Would Google collapse and the internet be destroyed if YouTube and therefore Google were potentially liable for posting and refusing to take down videos that it knows are defamatory and false?
Well, I don't think Google would. I think probably every other website might be, because they're not as big as Google. But here's what happens. I mean, you do have that situation in Europe, but there's not class actions, there's not plaintiffs' lawyers, there's just not the tort system. So what you would have is a deluge of people saying, that restaurant review was, you said my restaurant review, I didn't like it. I think Yelp does an amazing job on this about how much they got hit and had to spend, almost crushing litigation because they were being accused of being, biased on reviewers, and everyone, no matter what, they couldn't win for losing or lose for winning, whatever the phrase is, because whoever got reviewed, somebody was upset. And so I think those websites, they never would have happened, and they probably would collapse.
Justice Alito?
Well, the secretary did what he did. So presumably he had and has a view about the fairness question that the Chief Justice posed to you. What is that view?
So the Secretary understood the statutory authority and mandate here to focus on whether this national emergency was going to leave borrowers worse off because of the pandemic. This is Congress deciding that the government should be in a position to provide benefits solely within the context of the student loan program. And I don't think there's any part of the statutory analysis. This is Congress's judgment that borrowers should be able to get relief if the Secretary makes these determinations, with no suggestion that the relief should turn on or off based on the possible impacts on those outside the student loan program. Congress obviously knew when it was giving this authority to take care of borrowers who are otherwise going to be worse off that might have otherwise impacts outside the program, but it wanted to make sure the Secretary could provide relief to borrowers.
Was the Secretary legally obligated to do what he did?
No, he's not required to provide relief under the HEROES Act.
So he decided to do what he did and must have had reasons for doing it, and some of them are on the record, some may not be, but the Secretary, if you're right, then the Secretary presumably could do more, and therefore I think it's a fair question to say what is your client's view about the fairness question that some people have posed, and that was reiterated for you by the Chief Justice.
The view of the department is that this
Why is it fair?
warranted.
Why is it fair? If it was just, if he didn't have to do it, why is it an answer to say that it was warranted? Maybe it was warranted, but why was it done? I guess you don't want to answer the question.
It was fair because in the absence of this relief, it's undisputed that there are going to be millions of student loan borrowers who are not going to be able to pay their student loans, who are going to get into default and delinquency. And the HEROES Act was specifically designed for this situation. This is Congress telling the Secretary, you don't have to let that happen. And when we have this kind of a pandemic that requires this kind of relief, I think that the HEROES Act is operating right within its domain.
I'll try one more time. Why was it fair to the people who didn't get arguably comparable relief? Now, it may be that their interests were outweighed by the interests of those who were benefited, or they were somehow less deserving of solicitude. But what is your answer to that question?
My answer to that question is that Congress has already made the judgment that when there is a national emergency that affects borrowers in this way, the Secretary can provide relief. And you could make this critique of every prior exercise of HEROES Act authority. There, too, you could say, well, that only benefits the specific enumerated affected individuals, but it's Congress who defined those individuals, and the Secretary acted properly here in giving them relief.
Justice Thomas? Justice Alito?
Under your test, citizenship is irrelevant, right?
That's correct.
But in Steele, it seems to have been quite relevant. The very first sentence of the opinion points out that it defines the issue, and it refers to a citizen and resident of the United States. So you are really asking us to overrule Steele in part, are you not?
We do disagree with that aspect of Steele. Now, it's not presented here, so you don't need to opine on it. We think the better reading is that it's not that it's not a relevant factor. But there are, for instance, Steele also reached his conclusion as a matter of subject matter jurisdiction. It thought this was a question of subject matter jurisdiction. It's pellucid under this court's precedents. That's not correct. And I don't think the court would have any hesitation in saying, well, that piece of the reasoning was incorrect. And so we view the citizenship as a little bit of something you can set aside, just given the ability to apply the modern framework and replicate kind of the heart of Steele in terms of the confusion.
Well, I'm not sure how that links with the issue of stare decisis. So are you saying that Steele has already been essentially overruled, or are you saying that we should partially overrule it by getting rid of the citizenship element?
I guess I think of stare decisis as attaching to the holding of the case, and particularly because it doesn't set out a particular test. It just sets out these three amorphous factors without saying how they should apply. The courts of appeals have taken themselves as free to form different tests based on Steele because of how amorphous it is. So I don't think anything needs to be overruled, even though there are aspects of Steele that the court would not bring forward. But again, on the citizenship in particular, while we don't see a principled reason in the text that citizenship should be relevant, and so it's hard to turn on that as a distinction of Steele, the court does not need to opine that in this case because this is not a U.S. citizen.
Well, if I were looking for the holding in Steele, and I were back in law school, I might look at the first sentence of the opinion, which says the issue is whether a United States District Court has jurisdiction to award relief to an American corporation against acts of trademark infringement and unfair competition consummated in a foreign country by a citizen and resident of the United States. So you say it's not a jurisdictional issue, and it doesn't matter whether it's a citizen or a resident of the United States. It sounds to me like you're asking us to overrule Steele in part.
Justice Alito, if you read that as the holding in Steele, then I think that this is just a situation where Steele presents no impediment because it's not a U.S. citizen issue, and then you would kind of take Steele out of consideration in deciding between us and petitioner's position, and we think that our position about what the focus of the statute is the correct one from first principles. The core of trademark is trademark infringement is consumer confusion, and if ever there were an object of solicitude, I think this is a really good example, in addition to being really parallel to the structure in Morrison.
Counsel, Justice Thomas, anything further? Justice Alito?
I take it your short answer to Justice Sotomayor's hypothetical, where let's say the survey shows 25%. Let's say it shows 30%. Your answer is that has to go to the jury.
Well, we cited the Dark Knight case, the Forbes case that was resolved on
Would it go to
Twombly.
the jury or not? Can you give me an answer?
I think it would probably, I mean, it just depends if there was something wrong about the survey, but I don't know if it would not go to a jury. It could go to it could be resolved on summary
It
judgment.
would go on summary judgment
Yeah.
in favor of the Republican Party or the Democratic Party.
Well, depends. Unless it meets 12b-6, it survives a motion to dismiss.
Let me give you some other. Let me give you some other examples that are in the briefs. I'm sure you're familiar with it. So this is from the Electronic Frontier Foundation's brief. So here's a poster. Let's say this is on a T-shirt. It says diamonds. It's got a picture of two hands. One has a diamond ring on it. And at the bottom it says, your purchase of diamonds will enable us to donate a prosthetic to an African who lost his hands in diamond conflicts. And at the bottom it says De Beers, from her fingers to his. Let's say that's on a T-shirt. What about that?
Well, I don't think that's going to be likely confusing. If it's diluting, it will have an exception for fair use unless that does not look like a trademark use. But if that becomes a line of books, movies, TV shows, and you're selling all kinds of mugs and coffees, then you would not have the fair use exclusion. But yeah, you've got, the more it says something ridiculous or condescending about the brand, it's so likely to not be confusing. You always run a chance that you might have a dilution claim, but there's a fair use exception and a non-commercial use exception that are pretty robust.
Could any reasonable person think that Jack Daniels had approved this use of the mark?
Absolutely. That's why we won below.
Really?
Yes, but
let me envision this scene. Somebody in Jack Daniels comes to the CEO and says, I have a great idea for a product that we're going to produce. It's going to be a dog toy, and it's going to have a label that looks a lot like our label, and it's going to have a name that looks a lot like our name, Bad Spaniels. And what's going to be supportedly in this dog toy is dog urine. You think the CEO is going to say, that's a great idea, we're going to produce that thing?
No, but Nationwide ran a Super Bowl commercial with a dead child in it, and they had to pull it because it was such a bad idea. I don't know who approved that one. It was really embarrassing for them.
So a reasonable person would not think that Jack Daniels had approved this.
I think if you're selling urine, you're probably going to win on a on a 12b-6, but you're probably also violating some state law. But sure.
No, you're not selling urine. It's exactly this toy.
I'm sorry, I thought it was.
No, it's exactly this toy,
I'm sorry.
which purportedly contains some sort of dog excrement or urine.
Okay, my bad.
The CEO is going to say, this is a great idea.
Well, just showing how confused I was suggests that I would be your perfect consumer. Justice Alito, I don't know how old you are, but you went to law school. You're very smart. You're analytical. You have hindsight bias. And
Well, I
maybe
went to a law school where I didn't learn any law. So no.
Okay, but it's just a little rich for people who are at your level to say that you know what the average purchasing public thinks about all kinds of female products that you don't know anything about, or dog toys that you might not know anything about. And so I don't know.
I had a dog. I know something about dogs. The question is not what the average person would think. It's whether this should be a reasonable person standard to simplify this whole thing.
So since 1976, you've had this appreciable or substantial number of confusion. And again, I think the best example is just you can enact a rule that says likelihood of confusion by judges or likelihood of deception. And if you think that's the average reasonable judge, okay. But I don't know how you would do a survey on that. And if you think there's something wrong with the survey, you can dismiss it. The court in Booking said surveys have to be done with careful design and careful reading. And the court can reject the survey.
Well, I'm concerned about the First Amendment implications of your position. And you began by saying by stressing that Rogers is atextual, it was made up. There is a text that says that Congress shall make no law infringing the freedom of speech. That's a text that takes precedence over the Lanham Act. And you said there are no constitutional issues. But your answer to Justice Sotomayor's hypothetical tells me there are important constitutional issues.
Allow me to push back with the founding. Trademarks have been around since the 1500s. They predated the First Amendment. Same way with copyrights. And this court has had 4 cases, the San Francisco case, the Zucchini, and then your Eldred and Harper and Row. And you said on all 4 of those cases, even if it didn't involve confusing speech, it didn't involve any kind of intent, it didn't involve any kind of those were all harder cases. And so it's a property right. I agree when you don't have property rights, but the definition of a property is it's going to infringe someone's speech. It is a limited monopoly as long as alternative.
Well, is it your argument that anything so long as something is protected by the Lanham Act, there is no First Amendment issue?
Well, when you say, I think that unless you're going to bring it as applied, you have to, it's confusing speech and it goes to the dilution. But yes, I think the Lanham Act is clearly constitutional. You all but held that in the San Francisco case.
No, the question isn't whether it's constitutional. The question is whether it should be interpreted, and this is where Rogers may come from, in a way that does not bring it into conflict with the First Amendment.
Well, then you should strike the statute as either facially invalid or as applied to a dog toy. It just seems that you're overturning centuries and billions of dollars of brand investment as to confusing. What I hear you saying is that you're worried about, you think, are non-confusing uses, but courts have been, I think we cited it on page 25, case after case that rejected parodies. Notably, none of those had survey cases. There are lots of famous cases where the court rejected likelihood of confusion. And as to dilution, again, there is a Supreme Court case on point, the San Francisco Athletic Association case.
Thank you, counsel. Justice Thomas, anything further? Justice Alito?
Mr. Stewart, do you think that the constitutionality of this provision could be sustained on a theory similar to the one in San Francisco Arts and Athletics versus U.S. Olympic Committee?
I don't really think so, because I think that was really not a provision of general applicability. That was intended to protect the trademark rights of a particular entity in a particular trademark, and there was a unique history and a unique motivation. Certainly some of the subsidiary things that the court said in that case would be relevant here. But the other difference is that in the San Francisco case, what you were dealing with was the actual imposition of a restriction on speech. That is, the consequence of giving the Olympic Committee exclusive rights in particular words was that other people who wanted to use the same words in their marketing activities couldn't use them. And what we have here is something different. We're not dealing with an infringement case. We're not dealing with the question, can Congress pass a law that makes it a source of liability for particular people to use particular words? Really, we have the flip side. The question is, can Congress refrain from giving people exclusive rights in particular marks?
I said what I think about the government benefits theory in Mattel versus Tam, so there's no secret about that. And if your argument if I could not vote to sustain this without saying this is the attachment of a condition to a government benefit, or that it's analogous to the attachment of a condition to a government benefit, you don't need my vote to win your case. I'm trying to see if you have any argument that maybe you've just decided, well, Alito's a lost cause here. But whether you have any other argument, that one that doesn't require me to accept either of those propositions.
I'm not sure if this is fully responsive, because I do think at some level our argument in this case depends on the proposition that there is a difference between telling Mr. Elster you can't register the mark Trump too small, and telling him you can't sell shirts with that slogan emblazoned across it. If you think those two hypothetical restrictions are one and the same, they are legal equivalents, then we don't think that we can persuade you because we don't think any government could prevent him from selling the shirts.
Okay, let me just ask one final question. What should one do? What should a justice or a judge do in a case in which the issue is the constitutionality of the federal statute, and this jurist thinks that it might be constitutional under a theory other than the one that is advanced by the government in support of the theory? Should the statute be held unconstitutional under those circumstances, be under the party presentation rule, or should it be held to be unconstitutional as applied in the case at hand? What should one do in that situation?
I mean, I guess it depends in part on whether your objection is really to the theory or to the label. That is, if you, in the following sense, if you agreed that there is a constitutional difference between refusing to register the mark Trump too small and prohibiting the use of the mark Trump too small on T-shirts, if you agree that there is a legal difference between the two, but you're hesitant to characterize federal trademark registration as a benefit, we may still be able to persuade you because, as I said, the real question is whether this is an abridgment of speech. And for those purposes, at least part of the issue is there a difference between refusing registration and telling you can't market the shirts? The one other thing I'd say about TAM is TAM was a case, as you recall, in which members of a group of a musical group of young Asian American musicians wanted to register the mark The Slants, and they wanted to use that mark because it had historically been used as a derogatory term for Asians. And they said, our goal is to reclaim and assert ownership of the mark. They wanted to show that they weren't cowed by derogatory treatment from others. I think in that case, they had a real argument that to express themselves fully effectively, the Slants had to be the official name of their band. It wouldn't be sufficient if they had adopted a more anodyne term as the official name and then had referred to themselves colloquially as Slants. And so TAM was really the rare case in which there was real expressive value in choosing a term as a source identifier rather than simply using it.
Thank you.
Mr. Stewart, the extent of the government's authority to attach conditions to government benefits is a very difficult area of constitutional law and potentially quite a dangerous one. And as Justice Thomas pointed out, the situation here, maybe our precedent should be extended to cover this situation, but this is quite unlike any of the other cases that we have had concerning that. So my question is, if we don't agree with you on this theory, does that mean that you lose this case?
I mean,
you have another argument.
I mean, I guess it depends on what you mean if we don't agree with you. If you think that this is the legal and constitutional equivalent of prohibiting Mr. Elster from selling shirts with the mark Trump too small, then we would say it's unconstitutional, at least applied in that setting, because we don't think that any government, state or federal, could prohibit Mr. Elster from selling those shirts. That is constitutionally protected expression. If you think that this is meaningfully different from a prohibition on speech, it is a condition on the federal benefits that go with trademark registration, but it still warrants heightened scrutiny. We would say it can satisfy heightened scrutiny under those hypotheses, because here, I mean, it's not just a government benefit. The particular government benefit that Elster is seeking is enhanced mechanisms for restricting the speech of his competitors.
Mr. Stewart, I'm sorry to interrupt, but I just want to see if I understand your response to Justice Alito. And I may not. But if we put aside the emphasis on whether this is a government benefit and try and avoid writing a rule that might have ripple effects outside of intellectual property law, right? And we've been discussing, this is quite unlike a lot of government benefits. And focus instead on history and what that informs us about the use of names in this context. There's a long historical tradition, right, of the living person name, just as there is with geography and other things like that. There have always been content-based restrictions of some kind in this area. Is that enough for us to say, to resolve this case in your favor, or do we need to, I think what Justice Alito is pressing at is, to rule in your favor, do we need to go down this government benefits route?
I mean, I think federal trademark registration dates back to 1870, so it's been around a long time. It hasn't been around since the founding.
Well, there's common law before that, right? It's not like this came out of the ether.
I mean, there certainly has been a long tradition of thinking of living individuals as having certain proprietary rights over their own names. And here the question is not just whether Mr. Elster can use Donald Trump's name, because he can. He can market expression that is about Donald Trump. The question is whether he can assert an exclusive right to use Donald Trump's name and prevent his competitors from doing so. Now, another answer I would give to Justice Alito is an important limitation on our argument here is that Mr. Elster can sell shirts with the slogan "Trump too small," and he can obtain federal trademark registration so long as he uses a different source identifier that meets the statutory criteria for registration. And that's an important limitation, because the court in recent decisions has, like AOC, has cautioned against conditions on government benefits that seek to leverage government.
No, please, your turn. Have at it.
Keep going.
I suspect we're headed in more or less the same direction. The word government benefits again came up, and I guess I'm just asking, if I look back to the common law of trademark, okay, and if I look back to the earliest trademark statutes, I see a lot of what we now maybe describe ahistorically through our First Amendment lens as content-based. There are restrictions about geography, merely descriptive things, and living persons' names. Those have always been areas where there's been some limitation on the ability to trademark. And I guess I'm asking, why not just look to the history here and see whether historical evidence comports with this being a First Amendment liberty or not? I mean, why do I need to go down this, because the government gives it to you, it can do whatever it wants with you, road. And it's a very difficult and fraught road. And we have unconstitutional conditions doctrines and a million other things in this area. And I'm just not sure why I need to tangle with any of that.
I mean, certainly if the court feels that the historical evidence is sufficient to decide the case in our favor, we
don't object to that.
We don't object to that.
Just checking. All right.
Mr. Taylor, suppose Congress, suppose Congress passed this law. It says, because each living person has a trademark right to his or her own name, nobody can register a trademark containing the name of another person without obtaining that person's written consent. Would that be constitutional?
Well, it would be content-based, and so we think it would be subject to intermediate scrutiny. I think there'd be less a concern about leveraging if Congress was legislating on the understanding that someone had a trademark right in their own name. But I'd ultimately have to see the justification to see if it could survive. I mean, if we're talking about reason...
You mean the intent of Congress is when you talk about the justification, the reason for the sponsor sponsoring this, introducing the bill, the reason why a majority of both houses voted for it? Is that what you're saying?
I'm not suggesting, Justice Alito, that you would examine the legislative history to try to determine the motivations of particular legislators. To respond to that concern, I would just underscore that we're not here with just a couple of floor statements. We've got the text on our side.
All right. Well, let's put the legislative history aside, and let's say we know nothing about this provision other than what it says on its face. It says each living person has a trademark right to his or her own name. And therefore, you can't register somebody else's name without that person's consent. Would that be constitutional?
If Congress were right about everyone having a trademark in their own name, even if they didn't use it in commerce...
well, what if Congress says that they do?
I think it would present a closer question. I think you might, if you were to analyze that under a reasonableness standard and there was some real barrier on using someone else's name as a trademark, regardless of whether we're registered or not, I think that would be a very different question, because what's going on there is Congress is not trying to leverage the benefits of the registration system to do something that it can't do directly, which is to discourage people from selecting marks that are valid marks simply because Congress doesn't like the message conveyed there. And I think that is what is going on here. And, you know,
but do you think it's far-fetched to think that every person has an interest, almost a quasi-property interest in his or her own name?
Not at all. And I think that's why there's an exception.
Can Congress then protect it by saying somebody else can't take that away, in part by registering a trademark that uses another person's name?
I think Congress has already tried to do that with the separate surname provision that I was mentioning earlier. It's trying to ensure that, I mean, if everyone has a kind of there's a strong intuition we all have that we have an inherent property right in our own name and the ability to commercialize it, that you want to ensure that if someone's not just going to rush to the registrar to register the mark, Bob Smith, and then.
Well, are you saying that this provision would be constitutional if the subsection C would be constitutional if subsection A didn't exist, but because A exists, C isn't constitutional?
Well, I think that you'd have a question about fit at that point. So if 2A didn't exist, then 2C, in our view, would extend to prohibit marks that we think could properly be prohibited because they would be misleading or falsely suggesting a connection with someone when that connection doesn't exist. And so then the question would be just, did Congress go too far to deal with that problem? It would be an intermediate scrutiny question or maybe a reasonableness question that would probably filter out in the exact same place. But I think when you're assessing a particular law, you want to look at the practical effect. And so in the HIV/AIDS case, the unconstitutional conditions case, there was a separate prohibition on using the money for certain purposes. And the court said, well, assuming, because that provision already exists, we're going to look at this other provision, this loyalty oath provision, and it's got to be doing something more. And then we're going to analyze that something more that's doing to see whether it's constitutional. And I think a similar analysis would be appropriate here. And I think once you recognize that even if you were in reasonableness land, and most of these other provisions are going to sail through because they're consistent with the history and because they're ultimately just trying to ensure that trademarks function as trademarks and that they don't confuse or mislead consumers, then we're really just talking about one or two provisions that might have a purpose that's wholly disconnected from the purpose of trademark law. And I think what's so unusual about my friend's argument on the other side is that if the test is reasonableness for restrictions that are related to trademark law and the purposes of trademark registration, it's quite anomalous that for purposes that are totally unrelated, if the test is reasonableness for that for unrelated purposes where Congress is trying to leverage the benefits of trademark registration, you would have a lower standard, rational basis. That's exactly backwards. I think if Congress is trying to assert some justification that is outside the purpose of trademark law, whether it be dignity or a concern about, just people having a commercial interest in their own identity apart from whether it's a trademark or not, I think it's only fair that the government try to show that that's a substantial interest and that the fit is reasonable, and that looks a lot like intermediate scrutiny to me. So I think
so your argument is that except for someone who has been convicted of a felony, a person may not be prohibited from possessing a firearm in the home. Is that correct?
I would add one more caveat to it, Justice Alito, and that is if severe criminal punishment will result, because that is something that Heller itself and Bruin itself took into this balance, because the right that's protected is the right of someone who, by keeping the firearm, is used for someone who's keeping a firearm for lawful purposes. How does this regulation infringe on that? If it is a small fine or even loss of the weapon, maybe that doesn't violate that right. You could make it illegal. You're prohibited from keeping a weapon. But if we figured out that you had a weapon in your bedroom, you may have to pay for it, but you're not going to go to prison for 10 or 15 years. You're not going to get felony liability. I think all of those things together are incredibly important about this ban, because it is not based on loss of rights of citizenship. It is applied against rights holders. It is a total ban, and it is punishable by an incredible amount of prison time.
So let me give you this example. Suppose the state judge determines after a hearing that a man has repeatedly threatened to shoot the members of his family, has brandished the gun, has terrified them, and orders the man enters a restraining order preventing that man from possessing a firearm any place, including in the home. Is that constitutional?
I think the answer is probably yes. If he did, I think it probably is. I would want to know more about what the historical tradition showed, but certainly courts have always had broad power against the people who are brought before them. And I think that would be consistent with the historical.
So the difference you see between that order and the prosecution for violating the order is the fact that the latter imposes a felony punishment.
That's one difference, and it's an important difference under this court's case law. Another difference is that the defendant had a real opportunity, in standing before the court to say either, number one, I didn't do that, or number two, something was wrong with me, I'll never do that again, and I'll move across the country so I can assure you that they will be safe, but I'm very frightened to be, without my arms. So you would have a chance to entreat with the person who's putting in the restriction. If the restriction itself was unlawful, the person would have a chance to appeal it to a higher authority, to an appellate court, and say, this judge got it wrong. This is not lawful either under the Constitution or under this state's substantive law. All of those things are different in the situation that you describe, and I think they are constitutionally significant differences between that and what we have here.
One section of the provision at issue here applies when a court order includes a finding that the person represents a credible threat to the physical safety of such intimate partner or child. But another provision applies when the order, by its terms, explicitly prohibits the use, attempted use, or threatened use of physical force. That does not require a finding of dangerousness. Why is that necessary, and how can that be justified?
I think ultimately a court would have to find dangerousness to enter a subparagraph C2 injunction based on the general equitable principle that in order to enjoin conduct, you have to think that conduct is reasonably likely to occur. This is a universal equitable principle. It certainly applies in Texas and in virtually all of the states. And I think what it means is that a judge who's considering a request for a protective order wouldn't have a basis in law to enter that subparagraph C2 prohibition on the use of physical force unless the judge thought the force was sufficiently likely to materialize.
Well, we are told in some of the amicus briefs that there are situations in which the family court judge who has to act quickly and may not have any investigative resources faces a he said, she said situation, and the judge just says, well, I'm going to issue an order like this against both of the parties. Do you agree that that occurs?
No, I think that that is largely a mischaracterization of what is happening in the state courts day in and day out. With respect to mutual protective orders in particular, the vast majority of states, we cite a source that counts 48 of them, either prohibit outright or substantially restrict the entry of those kinds of mutual protective orders. And then I think the account is basically trying to suggest or insinuate that these state courts are nevertheless entering protective orders that are not justified by the facts and the law, and that just flies in the face of the presumption of regularity that this court applies in this context. Even the data on the ground don't bear out the assertions that family courts are just reflexively entering these kinds of protective orders. By respondents' own count, in the particular Tarrant County statistics he collected, there were 522 requests for protective orders, but that only resulted in 289 final protective orders. So I think even as a statistical matter, it's incorrect to say that invariably these orders are being entered without any basis in fact or law to justify them.
Is there anything that a person who is subject to one of these orders can do if the person claims that there wasn't really sufficient notice, or that due process rights were violated in some way, or that any need for the protective order has expired? Presumably the person could go back to the state court that entered the order, but if the state court is completely unreceptive to that, is there any other avenue for relief?
So I think it's important to parse out different aspects of the question. Certainly in a Section 922G8 prosecution, an individual could challenge the adequacy of the notice or the hearing. And so if the argument is I didn't actually receive the notice or I didn't have an opportunity to participate, that would be a defense because Section 922G8 requires that.
Yes, but before the fact, so the person thinks that he or she is in danger and wants to have a firearm, is the person's only recourse to possess the firearm and take their chances if they get prosecuted?
No, I mean, I think the person would obviously have an ability to, within the state court system, challenge the entry of the protective order. But I don't think there would be any basis to say you could collaterally challenge that in the federal prosecution. And ultimately, this just reflects the history and tradition demonstrating that there are certain categories of people where we don't have to tolerate the risks of armed domestic violence that they would present, even in situations where they might claim that they need to have a gun for other reasons.
There's no recourse before the fact in federal court.
So I think that they could seek recourse in the state courts themselves. They could protest the notice and the opportunity for a hearing. But if a court has entered a protective order that complies with the restrictions in 922G8, then a federal court can rely on that in enforcing this prohibition.
Is there any possibility of administrative relief?
I think that at the state level, there are certain mechanisms in place where people can seek relief. And one important thing to emphasize is that these protective orders are inherently time limited. It varies a little bit at the state level. I've seen provisions that authorize the imposition of these protective orders for 6 months up to about 5 years. I think most commonly they're in effect for just 1 year. But and the federal firearms prohibition tracks the length and duration of the protective order. So that also, I think, means that the disarmament lasts only so long as the danger is in effect.
Well, one more question. The Alameda County Public Defender's amicus brief says that some restraining orders are permanent. Is that true? And if that is true, how do you justify a permanent prohibition, even if any danger has disappeared?
So I'm not aware of state law authority that authorizes or that routinely enters permanent protective orders. As I mentioned, this varies across state law, so I don't want to suggest that there's a universal answer here, but these orders are generally time limited or provide mechanisms for courts to go back and review the finding of dangerousness for purposes of effectuating the basic command of the protective order.
Thank you.
Justice Alito?
Suppose that a jurisdiction enacted a concealed carry permitting regulation that is almost identical to the one we invalidated in Bruin, except that it requires an applicant to show that he or she is sufficiently responsible. Would that be constitutional?
So if that were implemented through a system of executive discretion, just as I was discussing with Justice Thomas, I think that there could be additional principles that come into play that would guard against that kind of licensing regime. Now, to the extent that that kind of background system was intended just to implement the bases for disarmament that reflect legislative judgments, and in other words, to check for whether you have a history of commitment to a mental institution or a criminal record or so forth, then I think those objective standards could be deployed as part of a background check system, and Bruin specifically suggested as much.
One more question. In response to my question about the provision that prohibits the possession of a firearm by someone against whom an order prohibiting violence has been entered, and the provision doesn't on its face require a finding of dangerousness. As I recall, your answer was that state laws generally do require that, and anyway, equitable principles require that. Now, suppose someone is later prosecuted for violating that provision. Would it be a defense for that person to say that the state law in question did not require such a finding, and in fact there was no such finding in my case?
I don't think that that would provide a basis to collaterally challenge the entry of the protective order in the federal prosecution, and we don't think that there should be a system of as-applied challenges in this context, because I think that what we know is that Congress is entitled to make categorical judgments, predictive judgments of dangerousness based on history and tradition, even if there are really edge cases where that predictive judgment wasn't actually necessary to guard against a danger there. But if what you're suggesting is that there might be a state out there that is ordering judges to enter the subparagraph C2 prohibition without any basis to think that physical force is likely, I think a person would have a very strong due process challenge to that kind of law, and that law would likely be invalidated on the separate basis that it doesn't provide due process if it's requiring courts to enter relief that the facts in the law don't support.